Welcome to another episode on the Larapo, episode 30. Today I would like to weigh in on the discussion waging in the United States of America following the Supreme Court decision overturning the case of Roe versus Wade. Disclaimer: I am an English trained barrister. I am not an expert in American law. But from reading the decision in the case of Dobbs versus Jackson Women's Health Organization, which ultimately overturned Roe versus Wade, and the subsequent case affirming Roe versus Wade, that of Planned Parenthood versus Casey, I have come to certain conclusions which I wish to share. But before I do so, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact a lawyer of your choice. I'll be back shortly. Welcome back. In a 6-3 decision in the case of Dobbs versus Jackson Women's Health Organization, the Supreme Court of the United States upheld the state of Mississippi law banning abortion after 15 weeks of pregnancy. However, 5 judges went further, ultimately overturning the 1973 landmark case of Roe versus Wade, which ruled then that women had a constitutional right to an abortion. Justice Alito, writing for the majority, wrote that Roe was on a collision course with the Constitution the day it was decided. It is time, he writes, to heed the Constitution and return the issue of abortion to the people's elected representatives. The Chief Justice, John Roberts, who joined the majority in upholding the Mississippi law that banned most abortions after the first 15 weeks of pregnancy, did not join the decision to the point of overturning Roe versus Wade. He insisted that the court did not need to overturn Roe. He wrote, and I quote, "Nothing, however, requires that we also take the dramatic step of altogether eliminating the abortion right first recognized in Roe." Writing for the minority, in dissenting against the majority's decision, Justice Stephen Breyer wrote, and I quote, "Neither law nor facts nor attitudes have provided any new reasons to reach a different result than Roe did. All that has changed is this quote. In my respectful view, this is a veiled criticism of the makeup of the court, which is deemed to be conservative leaning. The dissenters, however, struck a somber note when they wrote, and I quote, "With sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent." So, Roe versus Wade is overturned, and so too is the 1992 decision in the case of Planned Parenthood versus Casey, which upheld it. In my respectful view, the decisions were legally and constitutionally dubious and appears to be a constitutional intervention based on a liberal ideology rather than sound legal or constitutional basis. It was, in my view, judicial activism at best, granting a right that was not in the United States of America Constitution. The decision in Roe, in my respectful view, created a perception for 50 years that the court was some sort of super legislator with powers it never had, and that women had a constitutional right that was nothing more than the figment of the 1973 court's imagination. This is not a matter of being pro-life or pro-choice. This is my legal analysis. The fact is that the United States Constitution does not mention abortion, and so the court found itself in a position where it had to determine whether it was an implicit fundamental right that could be inferred, since it was not specifically mentioned in the Constitution. The court in 1973 found that the right was embedded in the constitutional right to privacy, even though no such right is mentioned in the United States of America Constitution. In the case of Casey, 20 years later, the court, apparently recognizing that Roe was on shaky legal ground, the court held that the abortion right existed not under the non-existent privacy right, but under the 14th Amendment to Due Process Clause, which provides that no person may be deprived of life, liberty, or property without due process of law. In my respectful view, a dubious legal rationale. What does due process of law has to do with a woman's right to an abortion? The court in the current case of Dabbs versus Jackson Women's Health Organization found that the reasoning in both Casey and Roe 50 years ago was deeply flawed from the beginning. It found that an implicit right must be deeply rooted in the American history and tradition. Clearly, abortion wasn't and had never been deeply rooted in the American history and tradition. Before the decision in Roe, abortion was outlawed by most states and was not recognized by any court until a few years before the decision in Roe. So what is the impact of the decision in Dobbs versus Women's Health Organization? Is that the decision of abortion, that issue, is returned to each individual state where it should have been in the first place. In my view, this is how a federalist system works. This is how democracy works. As the late Justice Scalia said, citizens should persuade their fellow citizen, who in turn should persuade their political representative to enact laws in their best interests. The late, great Justice Scalia went on to say, if they want a right to abortion, pass a law or amend the U.S. Constitution. It's that simple. Persuade your fellow men. In my view, it is disingenuous to say that the court in the decision in Dobbs ban abortions. It's simply not true. The issue of abortion is returned to the states. Women would still be able to get an abortion according to their state laws, or they could simply move to another state where the law on abortion in that state is more liberal. But the decision in Dobbs does not make it illegal, in my respectful submission, for a woman to have an abortion. Here is where I will leave it for today. Thank you for watching, and I see you in another episode.